is Teka Jerry Aondru. Yes, and I represent the fourth defendant in the subsequent judgment that was given. That's 889. Mr. Titus Zam in this matter. And you were in court. You could see all that played out by virtue of the sound judgment given by my lord. That judgment, I want to commend the industry being put in by my lord. That judgment is in line with the logic. That judgment is in line with the law. And the judgment is also in line with good reasoning. Now, the summary of that judgment is to the effect that the People's Democratic Party, who brought this action via an originating summons against our client and subsequent defendant in the matter, was being dismissed. And the premise upon which it was being dismissed is to the effect that the notice they claimed that was not given to INEC, the 21 days notice was not given to INEC, is not tenable in law. However, the court held in the contrary, that they held in the other position that they have the powers, quite okay, to institute the action by virtue of section 285, sub 14C. That was what played out this morning in court. So they have the powers to bring that action. A rival political party can sue another political party. But in totality, the court said the action entirely is lacking in merit. And that was what prompted the dismissal of that action. And quickly, we made cost to ask for cost. And that was what prompted me to ask for cost of 100 million naira for my client. My client has suffered. My client has been in court since from the inception of this matter. It has partly thwarted his campaign strategy. But to the glory of God, the judgment has shown the will of the Benue people. I'm not speaking as a politician, but I'm speaking on behalf of my client. My client is excited with the judgment, and we are happy with what played out today. However, the court granted a cost of 500,000 naira. Costs are not meant to be punitive, but it should send a deterrent that you cannot go about suing people unnecessarily. Your course of action must be within the ambit of the law, stricto sensu. And we are grateful with the judgment. And that is all. For 826, the earlier one given, where I'm representing Mr. Bernard Issa, that judgment also abide the earlier one I did mention. And we also got a cost of 500,000 naira in that particular one. Every reasoning of your lordship, of my lord, in that judgment was also abided in this 889. And we are very grateful. It has taken us a long time. It took us great energy to get to this stage. But they say justice moves at a slow pace. You understand? When it gets to the end, you get the victory of it. So we are all grateful. And
my name is Fidelis Bamson.
Sorry, you take it.
Can you take it?
Yes, sir.
Yes, my name is Fidelis Bamson, the State Legal Advisor, APC Benue State Chapter, and the counsel for APC in these two cases that judgment have been delivered today. Reaction to my judgment, permit me to say the judgment is very sound, and I will be very brief because I've given I've made a press statement on the previous judgment delivered by the same Justice Omotosha on the State Houses of Assembly, House of Representatives, concerning the same set of facts, same set of documents before the court. So I've given a detailed press statement on that. But let me quickly say the judgment is very, very sound. At least two very relevant positions of the new electoral act were put to test. Section 77 sub 2 and 3 of the Electoral Act 2022 that relates to submission of membership register to INEC 30 days before the day of election, and the issue of 21 days notice. Critical to the judgment, the court looked and analyzed the importance, the necessity of submission of the membership register to INEC 30 days to the day of election, how sacrosanct it is. But my lord went ahead to agree with APC, that's the second defendant in this case, that the APC have submitted the membership register, membership of each register, register of its members, even more than 30 days before the day of primaries complaint of. The government of the case of the plaintiff on that matter, they had a handwritten, what they call memo, that they circulated, they pleaded before the court to show that not all the register of members of APC in Benue State were submitted, that particularly Vandikia and Kasinala register of members were not submitted, and the target was to say that since the membership register from Vandikia, where Reverend Father Hyacinth Alia, the APC candidate for 2023 election comes from, was not submitted, so he has no business doing at the primaries. But the court looked at that document, and in summary, the court held that the document is worthless, belonged to nobody, no name was written. The document is purported to be official document from INEC, but there was nothing to show on the document, that the document emanated from INEC, that the document so pleaded to prove that register of members from Vandikia and Kasinala was not submitted bears no name. So the court simply said is a document signed by nobody bearing the name of nobody. And the conclusion that it's a worthless document. Yes, it's a worthless document. And then the court went ahead in appreciating the provision of section 82 sub 1 that relates to the length of notice. The court also agreed first and foremost that the 21 days notice is sacrosanct. But however, went ahead to say that APC as a political party gave INEC more than 21 days notice before the day of primaries. And the court went ahead to say that the notices relied upon by PDP, the notice of the 19th of May and 25th of May 2022 that they rely on, were only follow-up notices. The court appreciated and admitted the fact that the notice issued by APC on the 6th of April 2022 was more than sufficient before the day of holding the primaries. So I appreciate my Lord for giving an in-depth appreciation to these sections of Electoral Act 2022 and holding the favor of APC, and finally dismissing the case of PDP that the case is lacking. Well, like I'll speak for APC as a political party, we have trusted and believed in the rules of law. What we are saying to older political parties, don't panic. Let's play the games according to the rules, and don't forget, if you are contesting for any position, you will win that election to lead human beings and not bush or not trees. So every political party should embrace peace in the process of campaign and towards the election come 2023. APC is a peace-loving political party, and peace we are preaching to each and every political party and their candidates, that let peace rule us, and the rule of law should take precedence as we approach the general election in 2023. And we believe that by the set of candidates that we have and the issues-based campaign that we are canvassing, will be returned as winners of the election in various posts. Thank you.
Okay, so my name is Wilson Yoshe. I represent Honorable Memga Udende, who was sued as a third defendant. He's the candidate of the APC representing Benue Northeast Senatorial District. Now, the judgment today was an impressive judgment. My Lord addressed all the issues contained therein, particularly the issue of notice and the issue of register of voters. And at the end of the day, what you can see is that there's a lot of industry displayed by the court in arriving at the justice of this case. I'm glad and I'm excited also that my Lord was able to bring all issues to rest, and at the end of the day, it was clear that this matter was unwarranted in the first place. They shouldn't have brought this matter because it lacked merit, and the court was just to have dismissed the matter. Thank you so much.